How am I, I live on $1,000 a month. So paying $300, what am I looking at there? I've been on disability now for a few years and I live on, minimal funds, obviously, because they don't pay very much. So I just feel like, John has taken every advantage that he can of me in the past and still does. So I'm unaware about any, yeah, I think so. But there was the child support was completely stricken.
I don't see that order of 2012 was ever stricken, so it's still in effect.
All I know is that there was never any child support.
Is there an order that says that child support was waived? This is a motion for contempt brought by Ms. Wanzer related to medical expenses in Florida and also expenses related to travel for graduation of Hope. State your reasons why you think contempt is appropriate.
Sure, Your Honor. Just that they moved to Florida and that John had made some pretty big promises to Hope to get her to move to Florida with him. She did not really want to go. He is, assured the Ann Height that, he would pay for her round trips to come home for vacations, which did not happen, and was found in contempt for March when she came home because he did not pay. And moving forward, going to graduation, I had asked that, Hope, pick us up, as she had a broken car. And so I said, well, can you have your dad?
Funds are related to medical expenses in Florida and also expenses related to travel for graduation of Hope.
I don't have the money to rent cars. He made it nothing but harder for me to come. I'm on a very limited income. I'm on permanent disability. And he had stated that he would help me any way possible in accommodating me to come to Florida if I come to see her round trip. So that was that one. And I only put in for 50% of what I paid. I just thought that was fair. And also,
could I ask you a question on that, Ms. Wanzer?
Sure.
Related to your travel expenses to Florida, is there a court order that requires Mr. Miranda to pay for a rental car for travel expenses?
No, it was just stated that it was kind of a open statement there that he would just help me with accommodations when I came, if I were to come round trip.
Okay. All right. Thanks. And then why don't you tell me about the medical expenses?
The medical expenses, she's on his insurance and she got very sick a week before graduation and had to go to the ER. Also, she had, told her dad that she was sick and he was just like, whatever. And she had called me all day the day that she went, and she just, Mom, I just don't feel well. She got really sick. And then I said, well, make a doctor's appointment for tomorrow. By the end of the evening, she couldn't bear it. And I said, well, go to the ER. And so she tried to go to urgent care, and eventually she couldn't. She went to the ER and had to have a procedure. She was very sick and had to have medications for afterwards. Anyways, so this is, like I said, a week before graduation. And then she did ultimately get better. And, she, then John handed her, so anyways, I just kind of feel like she was still in school, that he should be taking care of her.
So thank you, Ms. Wanzer. Hope turned 18 on April 4th.
Yes.
And the hospitalization was middle of May, I believe, the 15th?
Middle of May. And she was still in high school, yes.
Okay. And then the temporary child support order, I saw that the child support order related to uninsured medical expenses was dated December 14th of 2012. So that's the document that I'm looking at. Is that the same document you're looking at that relates to uninsured medical expenses?
I'm unaware about any, yeah, I think so, but there was the child support was completely stricken.
I don't see that order of 2012 was ever stricken, so it's still in effect.
All I know is that there was never any child support. John had waived it. We had decided together that we had waived it. Also, and
is there an order that says that child support was waived?
No, we did it privately.
Okay. All right.
With support enforcement.
Okay. All right. And then let me ask you, looking at that temporary child support order from December of 2012, it says that there's a division of responsibility, that Ms. Wanzer would pay 31% and Mr. Miranda would pay 69%. And that order did not necessarily contemplate continuing obligations past the age 18, except for post-secondary education, where it specifically said that provision was reserved for the future. So if my understanding and assuming that order is still in effect, there's not an explicit provision that says that past age 18, the uninsured medical expense is obligatory on both parties. What's your response to that? Can you help me understand your?
Well, my response to that is that she was still in primary, she was still in high school. So if you're going to extend it through secondary school, wouldn't it, doesn't that apply through high school?
Well, the one specific thing that said that was reserved for future ruling would be post-secondary support, post-secondary schooling. So that was reserved. So there's no explicit mention of it at that time. So the other question is the billing statement that you submitted that lists, the insurance coverage and the amount owing says the responsible party is Hope Miranda. What's your comment on that?
Because she, of course, was the patient, so they sent it to her.
Okay.
It's under John's insurance, of course.
Okay. All right. All right, very good. What other information do you want to share about your motions for contempt?
Well, just that, that he has stated in the previous court hearing that we had in contempt, that he had made statements that he was didn't pay for Hope's plane ticket because he was providing her with a ticket to come home for the summer for an extended stay, which he hasn't. In fact, I just purchased her a ticket to come home next week.
Is that part of your motion for contempt? I didn't see that.
No, I'm just saying it shows to character of just how I can't count on his word even in paper.
Okay. All right. Thank you, Ms. Wanzer. Mr. Randall, what's your perspective on the two issues? Or I guess the one issue on the medical expenses, because I think the travel graduation expenses, there's no order that requires that. So I'm denying that motion for the contempt of that portion. So the focus is on the medical expenses at this point.
Yes, sir. So I provide insurance. I will continue to provide health insurance for Hope, my daughter, as long as I can keep her covered. But I had told her previously to schedule a doctor's appointment when she had first told me that she was having some pains. I was not like, whatever. I told her to go see our family doctor and schedule an appointment. Hope is a procrastinator and didn't do that immediately. So a day or two after she had scheduled an appointment after talking with her mom, she never made it to that appointment because she went to the emergency room that evening. I kind of had a conversation with Hope after returning from the emergency room, just letting her know that, the costs are going to be exorbitant because you went to the emergency room. Everything is, it seems like almost double. And I said, if you'd have gone to the doctor's appointment, something may have been able to be done at the doctor's, which would have been relatively cheaper, and the insurance would have covered a good majority of it. Granted, the insurance covered almost more than 90% of the emergency room, so that was great. I didn't think that it was out of question to help my daughter understand that the process of going to the emergency room, that a bill comes along with that. I asked her to contact the hospital, let them know the situation that she is in, that she just turned 18. She's still, just about to graduate from high school, in the hopes that maybe they would either waive this or move it to, to a minimal payback. That was my ultimate hope for it, Your Honor. And in asking Hope to take charge of that, it was, she would like to be treated as an adult. And, with the treatment of, asking to be treated like an adult comes this responsibility. So I asked her to take care of it. Next thing I know, I'm being served with papers as far as the contempt hearing here.
Okay, thank you. Let me ask you, if I may. So the temporary child support order of December 2012 indicates that there's a division of responsibility for uninsured medical expenses, a 31-69 split. My question, I guess, is that as the person providing the insurance to the insured, Hope, if there's a remaining balance, the obliger or the party responsible for that is the policyholder, is it not?
I would say that ultimately, yes, they would come after me if Hope didn't pay it. Yes.
Right. Yeah. If Hope decides not to pay it, then they're going to come after you for payment.
That is correct.
So, and this just happened in May, and now we're just barely into August. Okay. Okay. All right. That's helpful. Let me just look at one item here.
Your Honor, when you have a second, I have one more question for you.
I'm ready. Go ahead.
I was just wondering, now that Hope is 18, has graduated high school, and she is working. When is she actually considered an adult, and where does our parenting agreement kind of end when she is, considered an adult?
So there's a parenting plan that was issued on September 30th of 2022. And then when a person turns 18, the parenting plan is done, because she's a person of age of majority at this point. So she's no longer a minor.
Thank you, sir.
All right. Ms. Wanzer, do you have any just brief response?
Not really, Your Honor, just that, I've been on disability now for a few years, and I live on, minimal funds, obviously, because they don't pay very much. So I just feel like, John has taken every advantage that he can of me in the past and still does. So that's just, that's pretty much it.
Okay. All right. Thank you. All right. So there were two grounds which Ms. Wanzer brought a motion for contempt. The first was the travel expenses to Florida. So any order or any motion for contempt necessarily needs to be based on a court order, and then the allegation needs to be that a person violated or did not follow that court order. So as I mentioned earlier, there was no court order that required Mr. Miranda to make any expenditures related to travel for the graduation trip or what have you. So I'll deny that portion of the contempt. The other portion is that the medical expenses for the emergency room visit. It sounds like she wasn't doing well for a period of time. There was encouragement to take a different action. She got the help that she needed, whether it was timely or maybe a little later than hoped for. And then there's about a $1,100 bill that's outstanding. So the child support and health insurance is a little bit different in that health insurance generally parents can keep their children on their coverage up until about age 25 is pretty common across the country. And here we have Mr. Miranda's indicating that he's the obliger, he's the contracting party with the insurance company. So eventually they would come after him for the balance. But here there is an existing temporary child support order. It's temporary and it's old, but it's from 2012. It requires Ms. Wanzer to pay child support, but we're not here on that issue. We're here on that says that if there's uninsured medical expenses, then there's a split of 31% and 69%. So there's no clear indication that the child support obligation ends at age 18, because it's often common that children will turn 18 and still be involved in educational pursuits at the secondary level, high school. So here, I think that obligation continues. So both parties are responsible for the $1,049.89 in a calculus of 31% of Ms. Wanzer and 69% of Mr. Miranda. So that's what the parties are obligated to pay the hospital. As far as the contempt, I think there needs to be a willful and bad faith refusal to comply with the court order. So here, the court order is over almost 11 years old. There was in a relatively short period of time from the provision of services until the contempt was filed. There was some question related to age of majority and the like. So I'm going to deny the contempt, but just make clear that the parties are responsible in that percentage division for payment to the hospital for the services rendered to Hope. So I'm denying both motions for contempt. However, both parties kind of have a clear idea of what the responsibility is under the child support order from 2012, that 31% to Ms. Wanzer and 69% to Mr. Miranda. Do the parties have any questions, Ms. Wanzer or Mr. Miranda?
No, sir.
Yeah, Your Honor, actually I do. How am I, I live on $1,000 a month. So paying $300, what am I looking at there?
So that would be something that you could check with the hospital and work out payment arrangements through them. I know a lot of hospitals have charitable causes, and they have some flexibility in their payment plans, and they work with people. When people don't reach out to them, that's when they get concerned, I think I've seen in the past, but that would be your responsibility to work out something with the hospital.
Your Honor, if I may, just to bring it up, is Hope gets a stipend of Social Security benefits.
Your Honor,
that should probably go to that.
No, that, Your Honor, I object.
So Ms. Wanzer, as a general rule in my courtroom, I allow people to finish, and your objection is denied. There's not a legal basis for the objection. Mr. Miranda, you can finish your thought.
Yeah, so basically what I was saying is Hope gets a stipend from the Social Security that she gets along with food stamps that are provided. I watched this child since she has been getting it, because I have nothing to do with it, waste this money. So I think it would be very appropriate for this to go forward to that. I do understand your ruling is I'm obligated for the 69%. And if you rule I'm obligated to that, I will pay that bill to that. But Hope, being an adult, should have some kind of responsibility towards this.
Okay, thanks. So I won't make a ruling on that. That's something that the parties can work through. I get where the parties are coming from and teaching responsibility and accountability and financial wherewithal. I get that. So I won't rule on that. The parties can figure that out. Ms. Wanzer, any last comments?
Yes, I do want John to know that she was cut off months ago from Social Security. Okay. And that was as soon as she was 18. She no longer got any more money.
Okay. All right. All right. Thank you both. That'll conclude today's hearing.
I don't want him being charged more, so